Well, hello everyone and welcome to another episode of the TCLF One-On-One series. Through the One-On-One series, we aim to connect with the best legal professionals from India and around the world. And for this episode, we have the honor of hosting Mr. Sébastien Lafrance. And we'll be talking about a theme centered around comparative law, its utility, its role. And to talk about Seb's wonderful achievements, I'll just keep it short because it's a long list. I'll just try and keep it short. Seb is a Crown Counsel with the Public Prosecution Service of Canada at the moment. In the past, he has also served as a part-time professor of law at the University of Ottawa. He has also clerked with the Supreme Court of Canada, with the Quebec Court of Appeal, and he has been published by a number of journals of international repute. And he's a true scholar in the field of comparative law, international law, and other fields. Seb, it's really an honor to host you.
It's a real pleasure and sincere pleasure to be with you this morning.
Right. Seb, just to set the tone for the interview, you've overcome a number of odds to become a lawyer. So can you tell us more about your journey? What was the fundamental driving factor for you?
Two things. The first being, I've always been interested in, since I'm a kid, so I'm not going to make a long story, but since I'm a child, for whatever reason, because of my very poor background, and the only way to evade or I never thought, first of all, I would ever travel in my entire life because I come from a background where money was rare, almost didn't exist. Basically, we were surviving. So I got interested basically to flee my reality or evade or escape my reality. That's the only way I found as a child. So I got interested, and then it basically come to fruition throughout my life. And then when I started law, I tried to connect it to different countries, et cetera, et cetera. So that's the personal explanation, but also what I realized very early when doing comparative law, I gotta say, it is really an exercise in humility, because when you know your own law very well, of course, your own law, that means what? It doesn't mean I'm an expert in Canadian family law. I'm not. I'm far. I don't know much, but let's say you're fine or good in your field or various fields in your own country. When you approach this field in other countries, it is an exercise in humility, because the laws are different. There may be similarities or false friends, like we say. So some concepts may be the same, but interpreted differently. So it's nice to, when you think you're good, to wrap it up, when you think you're good and, oh, I'm so awesome, well, just go study the laws of another country. Well, you'll have a reality check, and you still basically brought back to the basics to understand the basics of the law. So that's good, right? Because when you're too much over self-confident, well, that's a good way to say, well, you don't know that much. So that's interesting to from that in that perspective, in that respect as well.
Right. Your journey, Seb, is truly inspirational. It's a journey which inspires others to just work hard and just aim for something and go for it. So that's truly inspirational. Well, just to take cue from your answer, how has your exposure to distinct legal systems helped you as a lawyer? And do you think that culture plays an important role in shaping up legal systems?
It does, yes, absolutely. 100% yes. It plays a role not only in developing legal systems, but also it plays a very important role in understanding legal systems. So basically, when you do comparative law, it cannot be limited to just an analysis of the legal norms, the legal situation that you can find in the legal texts. You must also absolutely take into account the realities of law in action, basically, in a country. So for example, if you have a look at the idea, the notion of multiculturalism, which exists in India, But it also exists in Canada, obviously. It also exists in Singapore and Indonesia. So you have this concept of multiculturalism. It's enshrined in section, that's provided by Section 27 of the Canadian Charter of Rights, that exists in other legal systems. So does it mean that multiculturalism, as it is understood in Canada, is exactly the same in India, in Singapore, in Indonesia? Of course not. So that word, just one word, multiculturalism, well, it has various interpretations just because of the culture and also the legal culture and also how it is interpreted.
Right.
So
yeah,
please
go
go ahead. Just one more little point. Also, being aware of culture when it comes to law, various culture, you also you got to be careful of what we call legal imperialism. For example, briefly, is when let's say I give a lecture about this notion on criminal law or constitutional law or comparative law in India, and I come with my big boots of Canadian lawyer, and then I impose my notions or my interpretation of this concept to Indians, whereas it's totally differently interpreted in India. So you got to be careful about this. So does culture plays a role? Absolutely.
And can you just also tell us more about your exposure to distinct legal systems? How has it helped you?
It's exactly like languages, right? So when you, because of course English is not my first language, it's my sixth language, so you probably can hear my French accent here. It does help. So, for example, when you learn a different language, it brings you back to the basics, to the grammar, to speak better, as much as possible, of course, your own language, because you realize things about your own language. So that the same phenomenon happens with the exposure to different legal systems. You learn the flaws of your systems, you learn the qualities and the greatness of your system. There are things I didn't know which were that great about the Canadian legal system that I learned because of India, because of Indonesia, Vietnam, etc., and vice versa. I've learned amazing legal concepts or great legal interpretation from India, Vietnam, Indonesia, Thailand, Russia, etc., just by the exposure. So there's an interconnection, right? So one helps the other somehow. So so it would help. I would say it helped me in that respect because it makes it puts things in perspective. Summarily said, so it puts your own system in perspective and the other systems in perspective as well. So you are more humble about your own greatness regarding the legal system you're in. Because sometimes you may think, okay, my legal system is the best. Why should I look at other systems? Well, no, your system is not the best. Your system is one system amongst other systems, period. So again, a lesson in humility.
Right. And talking about the interconnection, Seb, a number of scholars, including yourself, have argued that in an increasingly global and interconnected world, comparative law needs to take a center stage. But before we move on to the utility and role of comparative law, can you tell us what do you mean by this term comparative law?
Basically, it is very simple and it's very complicated at the same time. So comparative law means, if we keep it simple, it's to basically compare at least the legal systems, the legal norms of at least two systems. But the question that comes to mind is how to research it. And there's a quote, if I may say, it's only one sentence, but it really says exactly what I think about this. That's from Uwe Kischel, German, UWE space KIS or HEL. He published with Oxford, so it's that sentence speaks for itself. So he wrote, what exactly is comparative law and what is its contents? One can speculate almost endlessly over each of these questions. Why? Why is it so? No, some people who don't know or are not aware of the issues related to comparative law can say, well, it's simple. You compare X, that notion from this country with that notion from the other country. No, not necessarily, because like you just pointed out yourself earlier, there's the issue of culture, there's the issue of the interpretation. It goes beyond the legal norm. There are various variables that are unknown. So comparative law, can we define it specifically beyond being the comparison of two or more legal systems? It is not that easy. So that's why I found this quote from Professor Kisha very useful to explain it summarily, that there is an answer. At the same time, there is no fixed or predetermined answer.
Right. These definitions call for very important questions. So I'll just move one by one. To this, we come to the question: what is the utility of comparing these systems? Is it really necessary? Because can't systems work in isolation?
Yeah, my opinion is yes, it is necessary, even more so today. I will not serve you with the easy answer, the no-brainer answer of the globalization of the world. Some people even talk about, I don't believe in this, but some people are talking about that the world is globalizing right now because of the pandemic, because the systems are turning or closing or shutting out, whatever. So they're closing somehow to other systems, but still. Let me just give you a few examples, practical examples. The first one is trade. When there's, let's say, a merger or like whatever, the deals between companies from various countries, well, do you need to know the law of these countries? Absolutely. And how do you know the laws? Because again, the same concept, the same notion, even in for neighbors like the Americans and Canada, the same legal concept can have various meanings, not the same meaning necessarily, can have implications, can have different interpretation because of the jurisprudence and the case law. Same thing if we compare India, because there are many deals, commercial deals between India and Canada. Right. So same thing. So is it necessary in those cases? Big time, because if not, you're gonna put your clients, if you represent the company, in trouble, and you will probably lose your job. So if you don't give sound and good advice about the two legal systems. Another example, briefly, is that's an easy example for those who know public international law, but that's section 38 1C, section 38 paragraph 1 and subparagraph C of the statute of the International Court of Justice. Basically, what this section of the statute of the International Court of Justice, which is the statute of that is referred to all the time, it's basically common legal principles derived or stemming from various nations' domestic law using comparative law techniques, blah, blah, blah. So basically, that's the general law principles. So we can, the ICJ or International Court of Justice can use legal principles from civil law systems, from common law systems, as long as they're common. So the principles are common, even though they stem from various legal systems. Some have criticized it because they say it's European or Western-centric, et cetera, but in any event, we're not going to dive into this issue. But for example, there's the notion of unjust enrichment, the doctrine of unclean hands, etc. So these principles exist in civil and common law, in the common law system. Also principles eventually from Islamic legal principle can be included. So is it necessary? What's the role? Well, is it necessary? It is, right? Because otherwise you close yourself to important principles. And one last example, if I may, very brief. That's an example from a country you may know, a country called India. So if you look at the recent decision of the Supreme Court of India and the decision Putaswamy, very important decision about privacy rights. Well, what the Supreme Court of India did, it's helpful. Comparative law then can be very useful to interpret your own national laws. Because what the Supreme Court of India is doing in this decision, besides rendering a very, very important decision about privacy, what kind of sources do they use? They use sources and they rely on German law, but they cite principles from the Supreme Court of Canada. So, and vice versa, and that the Supreme Court of Canada also cited a few times decisions of the Supreme Court of India. So again, I'm not doing, I mentioned legal imperialism. I'm not doing that now. I'm not saying, oh, look, how Supreme Court of Canada is so good. No, it's not the idea. It's just because the Supreme Court of Canada was inspired by the Supreme Court of India in a few cases for identifying principles. So is it necessary? Well, yes, because it helps. Like I said, the exposure helps to understand your own national legal system. So if you just have a narrow mind approach to your own law and say, I don't want to hear about anybody else, what about new issues? What about novel legal issues that come up? If you don't at least look at what's done elsewhere, well, you're basically depriving yourself of amazing possibilities of understanding your own laws. So, and there are many other things that can be said, but about this. But yes.
Yeah, you've raised very important point, Seb, here, that there's a very important need to differentiate between realizing the role basically of comparative law. It's not to, as you mentioned, to look at some other legal system as superior or anything like that. It's just to understand your own legal system better with the help of other legal systems. And as you have rightly pointed out, the example of Putaswamy was then referred by many other courts around the world as an example of a judgment upholding the right to privacy. So that's a very important insight. Moving on to the next part of the conversation, Seb, as you've pointed out, a number of things influence, or a number of factors influence legal systems. For example, culture, the societal conditions, the economy, etc. So doesn't this make sometimes, obviously not always, doesn't this sometimes make legal systems incomparable? And how can we compare incomparable systems of law?
That's a very good question. But before we move on, I forgot to say it initially, but just a little disclaimer. So if I may, everything I say or said during this interview, it's only on me. It doesn't bind my work for the Public Prosecution Service of Canada. It's everything I say is on my behalf. So to go back to the question, is it comparable? That's the question. Because, for example, if you compare countries like India and Canada, both belong to the Commonwealth, both inherited their legal systems from the United Kingdom, while there's Quebec in Canada that has a civil law system that comes from France, but putting that aside for a second, there are so many similarities between the two systems that it makes it somehow comparable or easier to understand each other's system. What about incomparable system? Is there such a notion of anything incomparable? The best example that I came across for this is comparing Vietnam and Canada, because Vietnam has a different economic system since that's a socialist or so-called communist system. Even since the Doi Moi, which is the equivalent of the perestroika or glasnost that happened during the 80s. They opened to the national market, but still they remain a different economic system, different political system. And that also has an impact on the law. So and that brings I will just give you an example. When I compare the presumption of innocence basic principle. Basically, you're presumed innocent until you're found guilty by a court of law. That's for criminal proceedings. In Vietnam, this notion also exists in criminal law. If you look only at the English version of what is provided by the criminal code, or it's not called this way, obviously, but the equivalent of the criminal code. So basically, it looks the same. So it's okay, yeah, this is comparable, but at the end of the day, it's totally different. It's not when you read Vietnamese, which I did and do, the Vietnamese version, it's not what it says. It's different. So it's the presumption to not be guilty, which is not exactly the presumption of innocence, right? So what do you do? Well, you have to, but of course, I'm not saying that the Vietnam and Canada are not comparable. They are. For example, I've read recently a PhD thesis that compares Sweden, Australia, and Vietnam. And that was a thesis from Swedish University, not about the presumption of innocence, about bribery, I believe. So it's there's no such things as being incomparable. Everything can be compared, but when you come across systems that are deeply different in various respects, what kind of things does it raise? It does raise the issue and kind of an alert, a red flag in your mind. Okay, I got to be careful about culture. Got to be careful about political system. Got to be careful about the structure of the legal system. I got to be careful too about culture itself, not even legal, how things are done. So all these things, right? So I would say that there is no such things as legal systems that are not comparable, but when there are lots of differences, you got to be very careful, because it's easy to say, okay, X can be compared with Y. You just compare one with the other, and there you go. But no, there is way more. There is a methodology to this madness, should I say?
So certain systems are easier to compare than others, right? So that's the basic notion. Just out of curiosity, Seb, like, how do you recognize the standards of comparison? If you could give an example, because you've been studying this law from a long time, how do you recognize the standards of comparison? What is the methodology that you adopt?
There are various standards that exist. There are even issues and debates as to how it's done. If I come across, for example, the most well-known way of doing it is simply, like, I just identify the differences and similarities, and not of legal norms. I'm sorry, I don't know if I was heard. But is that enough? I don't think so. So in terms of methodology, let's say you have the Indian Penal Code or Indian Criminal Code. You go through the for example, let's take one offense, rape in the Indian Penal Code. Okay, you compare. You have the notion of rape. Do we have rape in the Canadian Criminal Code? No, we don't. We have the offense of sexual assault. So different terminology from the very beginning. In India, there are many more. Just a jurisprudential explanation, very briefly, but in basically the offense of sexual assault, we had rape before, but it was so narrowly defined that basically now the way sexual assault is defined is very all-encompassing. So as long as, and I really summarize here, it's more complicated, but as long as something an action is done with a sexual purpose and it's not wanted by the other person. So basically, I blend several Supreme Court of Canada decisions now, but as long as it is for a sexual purpose, it may be qualified as a sexual assault. Even a kiss from a full sexual intercourse. But in India, it's not this exact same definition, right? So it's different. So you see these two things. So if you just compare differences and similarities, when it comes to the terminology used. In this context, the example I just gave you, well, what's the conclusion? Well, oh, it's not comparable. That's totally different. So you see, if you really restrict your mind to what's the definition, it's not working. But of course, it's not the case. It is comparable. Of course, it is comparable. So the methodology would be really to identify, to go back to this notion of legal culture. So how, and also legal culture is also important because there are offenses that are provided as such to be offenses because of the culture, not the legal culture, but because of the facts, the reality. So the reality inspires the law. The reality, or for example, the domestic violence in India. So there was of course it exists in Canada. It does exist. It's unfortunate. More than 1 million women in Canada have been victims of domestic assault. So I'm not trying to diminish the importance of it in Canada. It is horrible. It's unbearable. But in India, there was a kind of a crisis that basically led to the adoption, the enactment of specific legislation, right? So facts inspire the law. So when you go to the study of comparative law, you have to look at the facts, okay, what happened? Why? That's the question too. Why this legislation exists? Why this article of the criminal code, or why is this constitutional law provision exists? There's always a reason behind. So it's not out of the blue, it's created. And just to wrap it up, one last example. This is why, that's not the only reason why, but this is one of the reasons why after the Second World War, in Japan, the constitution was basically drafted and imposed. They're drafted by foreigners and imposed by foreigners and Japanese. Why is it so offensive? It's just a constitution. Why should we care? It's just a piece of paper. No, it's not, because the Constitution, it's the fundamental principles of your country. There are principles in the Constitution that may not, maybe it does, but that may not reflect the reality, the facts, right? So that's one example. But again, the facts. So if you look just at the Japanese constitution and you say, oh yeah, that's beautiful, that's not interesting, blah, blah, blah. No, there are facts behind it. So in terms of methodology, to summarize, so yes, differences and similarities between two legal systems, between legal norms, but also second, the legal culture, and also third, the facts behind that justify the existence of a legal norm or a legal system.
Yeah, I think a very important deduction which can be made from the entire conversation is that the correct narrative would be to say that there are certain differences between these systems, and these differences, you've been able to recognize them through the comparison that you have taken, rather than saying that these systems are not comparable as such. So that's a very important distinction that you have pointed out.
Thank you.
Now, coming to your own personal experience, you've in the past argued for comparing systems in India and Canada and multiple other countries, as you mentioned, or Vietnam, Indonesia. So what is your purpose behind taking up this study? What do you intend to do with it?
Why am I laughing? Personally, I will answer briefly, but it's a very cheesy and naive answer, but I have to say it because it's the truth and it's honest. Make the world a better place. I know it's so naive, but I'm 45 years old, soon to be 45 years old. I still believe that we can make the world a better place, which is a good thing, hopefully, and which is something that I look forward to eventually. Of course, I'm not that naive thinking it's going to happen, but so that's the personal purpose behind it. The second personal purpose behind it is exactly like I said, reference to legal culture and also the importance of languages. Because basically when you study the law of a country, you have to bring your, because of my love for foreign languages or various languages, and the fact that I learned them, of course this is helpful, and sometimes it is important. So to go to a more professional like answer, what I said about the Vietnamese presumption of innocence, for example, if you just look at the English version, you're going to think, okay, this is the exact same thing, so our systems are the same. If you look at the Vietnamese language version, and I'm not the only one to say that, actually, I based my conclusion to say that there's an issue on Vietnamese writings written only in Vietnamese. So if you don't know the language of the legislation, you just rely on secondhand or translation of it, basically you may be misguided, and draw a wrong conclusion about what needs to be concluded and thought, right? So the purpose is really to push science further, to basically also, it still connects to my naive idea of make the world a better place, but help legal systems and people, because there's always people behind the legal systems. Make people talk to each other, not stay in isolation in their bubble, but feel free, right? So it's breathe and open their minds to other legal system, discover things. And this is done through not only the study of legal systems, but also the language behind it. Of course, with India, the legislation is in English, so it's not that much of a problem, but still you may have heard I started learning Hindi and so on because I want to eventually learn the facts. And to learn the facts, well, with English, it's not sufficient. For other countries, like Vietnam, Indonesia, etc., or Russia, it's if you don't speak the language, just rely on documents translated in English or French, because I'm French speaker originally. It's not enough. So make the world a better place, I guess, would be the best answer. But still, I still find it very naive, and I cannot believe I'm that naive. But what can I say? But I truly believe in it, because I've seen, and I have to say it, I've seen magnificent things happening between connecting people together from various countries. So yes, I'm laughing, and I seem to take it very lightly, but no, I truly believe in it, and I think that it is quite important to connect different countries together. So basically, to wrap it up, I was saying at the very beginning to make the world a better place, and I smiled and smirked and laughed a little bit about it, but actually I truly believe in it, and I think it is important. That's the main purpose, or the fundamental purpose behind me doing my best to compare legal systems, sometimes what we may call legal systems that are difficult to compare. I have seen personally magnificent things happening, people from being able to connect people between various countries, mostly in Asia, but also in North America and Asia. So people to talk to each other, to open their minds, to open their basically Weltanschauung, to use a very fancy German term, which means how you see the world, what is your conception of the world. So basically expand your views and your understanding of your own self. Because let's go back quickly to Socrates, who said, know thyself. But I truly believe that you will know better yourself by comparing yourself to others, and that includes other legal systems. And also, it makes the world a better place to the extent where, make friends, right? So at this very moment, for example, that's the best example. I am talking to you guys in India. I am in Toronto, Canada. So that's one example amongst many of them. So that the purpose behind it, yes, I made fun about and laughed at myself about making the world a better place, but the fundamental purpose behind it, it is what it is. That's what my purpose is, basically.
Well, Seb, this was truly an enriching conversation, to say the least, personally for myself, and I believe for all viewers. So, do you have any concluding remarks, any advice, any message for our viewers?
Uh, the message that I would say is, and really in light of comparative law, because that's the topic today, and I want to connect my advice to it, is don't be shy of being curious about other legal systems. And if you tell yourself, oh, I don't know anything about it, I'm so ignorant about it, that's the beauty of it, discovery, because you will feel like Christopher Columbus discovering America by opening books that you like from a new legal system you have no idea about. And I can tell you for sure, this will never be a waste of time. Like, for example, briefly, when I went to Sweden, they were talking to me, I presented there, and they talked to me about the ombudsman, system and so on. And I said, well, that has no connection in Canada, really. But no, it was, I learned from it. In the spur of the moment, I thought that I was wasting my time. But afterwards, I realized absolutely not. So open your minds, open your soul, I would say, because it goes that deep to other cultures. And also it helps to travel. So some of you, as I did when I was a child, I didn't have money. My only way to travel was with my mind. So you can travel this way for cheap because it's only the price of a book, or the book at the library you can borrow. Then you can travel with your mind and soul. So that's what I would say. Do not be shy ever of doing this.
That's fantastic, Seb. Thank you so much for joining us today. It was truly an honor once again to host you, and we're looking forward to more collaborations with you in future. And we have had a very good relationship. And thank you so much once again.
My most sincere pleasure. It was I had a lot of fun talking to you this morning, and thank you very much for welcoming me this morning. I'm very honored as well. Thank you so much.